Hello friends, welcome to Insight, and here we are going to talk about very important issue which is called Office of Profit. Recently, you might have heard a news that some 11 MLAs of Aam Aadmi Party, they've been disqualified on the ground of Office of Profit. So let us understand what are the basic criteria to disqualify these MPs or MLAs. Let's start with number one. What are the basic criteria to disqualify any MP or MLA? ध्यान से सुनिएगा. Basic qualification for MP and MLAs are laid down in Article 102 and 191 respectively. So they can be disqualified for following reasons. Number one, holding an office of profit under Government of India or a state government. Number two, being of unsound mind. हम इसके बारे में बात करने वाले ऑफिस ऑफ प्रॉफिट, पर ये बाकी के पॉइंट समझ लीजिए. ऑफ अनसाउंड माइंड, और he is undischarged insolvent. So he is insolvent but is not discharged, मतलब he is not able to repay his money, but he is not discharged, मतलब उनके ऊपर से जो भी केसेस है वो खत्म नहीं हुए हैं. And not being a citizen of India, or he acquires other country's citizenship. So this is how 4 points. On this 4 points, any MP or MLA can be disqualified. MP can be disqualified under article number 102 and MLA can be disqualified under article number 191. So we are talking about only one thing, that is called Office of Profit. So what is this Office of Profit is? The word office has not been defined in our Indian Constitution, or it is even not defined in Representation of Peoples Act 1951. But different courts have interpreted it in many ways and thereby giving certain character to this particular idea. So interpreted it to mean a position with certain duties that are more or less of public character. However, legislature cannot be disqualified from either the parliament or state assembly for holding any office. So कोई particular आपने office hold करके रखी है, सिर्फ mere that holding that office is not the ground to disqualify any MP or MLA. So what is this Office of Profit? So it can be done for holding, number one, an office. That office should be Office of Profit. Number three, office should be under union or state government. Number four, an office, you can say, exempt by law from the purview of disqualification provision will not be considered. So overall, these 4 conditions have to be satisfied before an MP or MLA can be disqualified. Okay, here we are talking about Office of Profit. So these 4 things are very important. Number one, he should hold an office. That office should be Office of Profit, and this office should be under union government or a state government. Okay, coming to the next point, that how do courts or EC decide whether an MP or MLA has profited from an office? Supreme Court, while upholding the disqualification of Jaya Bachchan from Rajya Sabha in 2006, has said this very clearly. समझिएगा इसको. For deciding the question as to whether one is holding an office of profit or not, what is relevant is whether office is capable of yielding a profit or pecuniary gain, and not whether the person has actually obtained any monetary gain. So एक person को actual monetary gain हुआ कि नहीं हुआ, that is immaterial. What is of material is whether that office has a capability to bring, whether that office has a capability to bring any pecuniary gain. If office carries with it or entitles the holder to any pecuniary gain other than the reimbursement of out of pocket expenses or actual expenses, then the office will be an office of profit. So कोई भी office अगर out of pocket expenses दे रहा है, which is not an office of profit, पर उसके अलावा कोई पिक्यूनियरी गेन दिला रहा है किसी को, then it is पक्का it is an office of profit. Coming to the next point is, however, a person who acquires a contract or a license from a government to perform function which the government would have itself discharged. So government ने खुद वो चीज डिस्चार्ज करी होगी, उस पर्पस के लिए किसी को कॉन्ट्रैक्ट में काम दिया है, then that person will not be held guilty of holding an office of profit. So acquiring a gas agency from the government or holding a permit to ply do not amount to holding of office of profit. Okay, so getting a contract is not an office of profit. You can say, coming to next point, the next point is, what is the underlying principle for including this office of profit as a criterion for disqualification? Okay, समझिएगा ये point. The makers of our Indian Constitution, they wanted that the legislature should not feel obliged to executive in any way which could influence them while discharging legislative function. भाई हमारे यहाँ पे जो legislative है, they are basically law making body. Their work is to make the law, and then there are executive, उनका काम क्या है? To execute the law. Okay, ये उनका काम है, to execute the law. और ये दोनों अलग अलग होने चाहिए. Legislature should not be obliged by executive to carry out any function. In other words, MP and MLA should be free to carry out their duties without any kind of governmental pressure, and that is a perfect reason why we have a criteria to disqualify office of profit. Coming to the next point, what was the first office of profit case referred to EC? So इलेक्शन कमीशन को पहला ऐसा कौन सा केस था जो ऑफिस ऑफ प्रॉफिट की वजह से रेफर किया गया था? 1953 में इलेक्शन कमीशन had to decide whether the MLS of Vindhya Pradesh Assembly should be disqualified for appointment as member of District Advisory Council. As member, they were paid an allowance of ₹5 for each day. They stayed at a place where the meeting of the advisory council was held. The EC was of the opinion that reimbursement, which is mere out of pocket expense, should not be held as office of profit. So only members living in the district headquarters where the meetings were being held and still receiving allowance were deemed to hold office of profit, and on that ground 12 out of 60 members were disqualified. So that was the first case. Okay, what are the recent instances? Recent instances were this: March 2006, President APJ Abdul Kalam disqualified Jaya Bachchan of Samajwadi Party from Rajya Sabha with retrospective effect from July 14, 2004 for holding office of profit because she was holding an office as a chairperson of UP Film Development Council. Also in January 2015, UP MLAs Bajrang Bahadur Singh, that is of BJP, and Uma Shankar Singh of BSP were disqualified from the assembly after they were indicted by the Lokayukt for bagging government construction contract for misusing their position. So this is how it happened in UP. Coming to next state, which is called West Bengal, Mamata Banerjee government appointed 24 parliamentary secretary for coordination between government and departments. So they were basically MLAs. Kolkata High Court called it unconstitutional. Matter is pending in Supreme Court. So far, this posts are currently non-functional. Coming to Karnataka, Karnataka government appointed 11 MLAs and MLCs as parliamentary secretary, says post not equivalent to Minister of State and they are only assistant to minister. The case is still pending in High Court. Rajasthan government has 10 parliamentary secretaries who enjoy status of Minister of State. So they passed a bill in October 2017 to give them constitutional validity. So currently it is being challenged in High Court. Orissa appointed 20 MLAs as chairperson of District Planning Committee in 2016 and gave them Minister of Status by amending the Act. The DPC get vehicles, secretariat staff, but they do not get any extra salary. So now this issue is unclear कि इसका क्या होगा. And then we have a Telangana. Telangana appointed 6 MLAs as the parliamentary secretary in 2014 and gave cabinet status by enacting the law. Hyderabad High Court caused the appointment in June 2016. Northeastern side पे Nagaland and Arunachal Pradesh have 26 parliamentary secretary each, and after Supreme Court held law enacted by Assam in 2004 unconstitutional, other northeastern state discontinued the post. 11 parliamentary secretary resign in Manipur, 7 in Mizoram, and Meghalaya High Court also held that Meghalaya Parliamentary Secretary Act is invalid and therefore the 17 people resigned. Talking about Haryana and Punjab, Punjab and Haryana High Court set aside appointment of 4 MLAs as Chief Parliamentary Secretaries in July 2017. High Court had struck down appointments of 18 Punjab MLAs as CPS by, you can say, SAD BJP government in Punjab on similar ground. Even Supreme Court had refused to stay the order. So, in nutshell, Office of Profit is holding any office which may gain certain kind of profitable benefit to the MP or MLA and which has a capacity to abuse the power of that MP or MLA. And that is the reason why they are to be disqualified. So I hope this is very clear to you. We thank you very much for watching this insight video. All the best.